And we're rolling. Hello and welcome to another edition of Car Brief. My name is Richard Elslager and I plan to tell you a scary little tale from the automotive crypts brought to you from the district court in this particular case out of Connecticut. I'm a licensed attorney. I practice civil law in Chicagoland, specifically personal injury involving automotive accidents, and also traffic law, bankruptcy, and associated other areas of law, general litigation. All right, now that's out of the way. Let's get into this case here. This is a case of McDonald versus a certain classic car company. I'll leave that nameless because I looked them up and they still exist. So I'm just basically protecting the parties and getting into the details of the case. Just there's some object lessons to be learned in this specific case. This one was decided back in April of 2003. However, this case arose out of plaintiff action brought by McDonald in March of 1995. Well, this case was on the cusp of a jury trial, and the matter settled before trial. It was about a week before trial, and it indicated that the parties had come to a consensus, they had come to an agreement, and various stipulations were obtained. And they were involving three different cars, 66 Shelby Mustang, which is the star of this one, also a 1950s Porsche, I think it was a 1952 Porsche, that's a very early Porsche, and a Jaguar from the 50s as well. Others also involved was a Della Hayes, that's a 52 Porsche, 59 Jaguar, and the 66 Shelby Mustang, near and dear to my heart, like the one that you see behind you, portrayed in that painting. Also involved was a Della Hay, a 1946 Della Hay. So there are a number of cars that were going on in this transaction. They reached a settlement. The magistrate, Judge Martinez, on June 21st of 96, recognized that the parties entered into a settlement agreement whereby the plaintiff was to and did receive from the defendants a check or $7,500 notarized general releases from the defendants, a 52 Porsche, a 59 Jaguar, and a 66 Ford Mustang Shelby, and bills of sale and indemnity signed by the defendants for the Porsche, Jaguar, and the Ford Mustang, which specified the vehicles were transferred as is, without warranty or representation except as to title. So that was part of the agreement that the parties entered into. In exchange, the plaintiff was to provide the defendants with an indemnity with respect to a 46 Della Hay and submit an affidavit and deed transferring the Della Hay to defendants, because at the time the title was missing or lost. So there was a little horse trading here. Not horses actually, but car trading going on to get a result, and the result was achieved. However, here is where the problem arose. Approximately 1 month later, on July 19th of 1996, the defendants filed their first motion to reopen and enforce the settlement because the plaintiff did not file the stipulation of dismissal and did not deliver to the defendants the promised documents. In the brief in support of the motion for a temporary restraining order, a TRO, the plaintiff argued that he was justified in failing to complete his duties under the settlement agreement because the defendants procured the title to the Della Hay by fraud by trading what was represented as a Shelby Mustang worth $38,000 at the time, when in fact the car was an ordinary Ford Mustang made to look like a real Shelby. Where have I heard situations like that before? Object lesson in this particular instance is join a car club. For example, if it's Shelby American Automobile Club is a very helpful resource to help sort through and prevent such calamities in your own personal life if that's the kind of car you're looking for. And it's a Shelby theme tonight. As you can tell, I'm wearing a new shirt here. Looks like a 427 Cobra. I think it's a semi-competition because it's got the little quick jack mounts there for the bumpers. It's got all the hallmarks of a semi-competition. They didn't make many of those. Anyway, getting back to the Shelby Mustang. According to the defendants, the plaintiffs demanded that the defendants immediately find and tender to the plaintiff an original grade A Shelby. Sounds like a package of eggs. A grade A Shelby, or replace it with $38,000. Wonder what kind of Shelby though. Was it maybe a blue Hertz? Maybe it was a black Hertz. Maybe it was a red Hertz. Who knows? Or maybe it was Ken Miles' number 98. Yeah, Ford versus Ferrari coming up. So we may see that actually in the movie. Kind of hopeful. Never know. It might make a cameo. We'll see. Well, the defendants rejected the plaintiff's demand, reminding the plaintiff's counsel that the plaintiff's classic car expert, plaintiff's classic car expert inspected the cars prior to delivery and the bill of sale as part of the settlement, specified in no uncertain terms that the three cars were being transferred without warranty. So it goes on, the court goes on to discuss the details of this transaction. Thus, the plaintiff is precluded from asserting any new claims against the defendant. As a result of this first unresolved conflict between the parties, the plaintiff filed a motion for a temporary restraining order to prevent the sale, transfer, or encumbrance of the Delahaye, which motion was granted pending the settlement conference on August 7th of 1996. So the plaintiff is trying to prevent any kind of a transfer or selling of the Delahaye. Well, they came up with a resolution again in front of the judge. So in addition to the plaintiff retaining possession of the three cars, the plaintiff agreed to keep the three cars, and the $7,500 received pursuant to the early agreement, the plaintiff would receive an additional $7,500 in exchange for plaintiff's waiver and release of any and all underlying claims or claims relating to the settlement. In open court, the plaintiff's counsel represented this. Okay, let's proceed here and see where we go with it. So they came up with a second settlement in any event. The plaintiff got another $7,500 due to the fact that what they got was not an original Shelby Mustang. So the defendants were good on their promise in the agreement, and they paid an additional $7,500, and the plaintiff executed and delivered the release, which included the release from all claims which could have been asserted, so on and so forth. So the releases were exchanged, and the parties filed a stipulation to dismiss with prejudice. Okay, so that sounds so far so good, but there was another problem that came in which resulted in more litigation. In 1997, the plaintiff, after learning that the Porsche that they received was not original, commenced an action in state court against the defendants for fraud in connection with the August 7, 1996 settlement and release, and for rescission of the release. The plaintiff claims that in order to induce him to sign the release and withdraw the district court action, the defendants represented to the plaintiff and Judge Martinez that the Porsche was an all original in excellent condition, and that there was no fiberglass in the bumpers. Apparently that's a big no-no in a 52 Porsche to have fiberglass bumpers. So now we got a second avenue of attack. It's now in the state court filed by the plaintiff, because now they're all angry about the Porsche. Now it's not just the Shelby Mustang clone, it's now the Porsche, which has fiberglass bumpers. Well, the case was indicated in the state court that plaintiff's qualified expert inspected the Porsche and found that the Porsche was not all original, causing the plaintiff to suffer damages of $45,000. And that's when the plaintiff filed their state court action. Well, later on, the defendants filed for a petition for relief, Chapter 11 bankruptcy in the United States Bankruptcy Court. So that stayed any further action in the state court until there was resolution or some movement in the bankruptcy action. When a bankruptcy is filed, everything has to stop dead in its tracks. Litigation, creditors calling, and so on. So that occurred, and the court went on in the bankruptcy court to decide whether the releases were enforceable. And the courts essentially held that these releases were enforceable, that they were very specific, they were very detailed in what was being released, and they held that the plaintiff released any further actions or any breaches of settlement agreement. They couldn't go forward with the action, so it was going to be enforced, because now the defendants are trying to enforce the terms of the settlement by reopening it, because the plaintiff is now suing them in state court for this Porsche that has fiberglass bumpers. Well, just to keep it short here and keep it brief, I'd like to keep things as brief as possible. Not always easy to do when you're dealing with the law, but to keep it brief, it looks like the court ultimately indicated that the releases were going to be upheld because the plaintiff was a sophisticated user, essentially. The plaintiff dealt with the buying and selling and display of classic cars, so the plaintiff essentially knew what they were doing. The court says, in part, the plaintiff was a sophisticated businessman and he was engaged in this type of business, and he couldn't be excused for failing to inspect or have the cars inspected that he collects and purchases and trades prior to the ultimate transaction. So the settlement was enforced, and the release was considered to be a good release. So what can we take away from this case? We can take away that first off, you got to be on your guard when you're dealing with collector cars, because not is all as it seems. These cars age, and as they age, they get changed. Even race cars, for example, like this R model. R models do change. Engines get blown up because in racing situations, the original engines typically don't last, so a new engine gets put in. Now it's no longer the original engine in the car, so the car's been somewhat changed, but is it still the real car? I would submit that it is, because it's the original body. Most of the time it's the original body, although those bodies get banged up, but the original VIN numbers are there, and essentially the chassis is original and the soul of the car is original, so it's going to be considered original. It depends on what you're willing to tolerate in the collector car market. Does it have to be 100% original? Well, you may be more inclined to spend a lot more money then to make sure that the car is original, or get a newer car that you know is going to be original and hasn't gone through all the hell that 50-plus-year-old car has gone through. But the takeaway is ultimately do your due diligence. Joining a collector car club is a great idea. I belong to the Shelby American Automobile Club, and they're a great bunch of people. They were very helpful and instrumental in me getting that car. Everything was confirmed. As far as the VIN goes, I won't say VIN number, because VIN is short for vehicle identification number. So if I say VIN number, I'm saying vehicle identification number. Doesn't make sense. So I'll try to be diligent in that regard and not be too repetitive. But that's pretty much all I got for tonight on this tale of woe. When you're ever dealing with collector cars or cars in general, it brings a lot of headaches. But this one got resolved, and there'll be more on the way. Take care and happy motoring.